am very, very honored to have Madam Register, Tracey Gordon, Madam Register, with us tonight. And I can't tell you how happy I am that she so graciously accepted this invite. But we have a special occasion. Madam Register celebrated her 1 year anniversary yesterday. Can we all give her woohoo?
Yes,
A
1 year.
round of applause. That is so awesome.
It's been pretty surreal. For the year have gone so far within my first 100 years and 100 days. Sorry, we was hit with the pandemic of the century, and COVID hit us, and it hit us hard, and it hit me way before my 100 days in office, and I had to think on my feet because I figured I wouldn't be judged. It would just be like, see, she didn't know what she was doing or whatever, and I had uh, put together such a wonderful team. I retained a lot of role employees that was already there, and we hit the show, hit the I'd say we hit the road running with just making sure that one of my campaign promises was to make sure that I educated all of the citizens of Philadelphia on what we do here at the Registry of Wills, and I'm also serve as the clerk of Orphans Court. And then my second promise was to make sure that we help people save their homes. And we started a program that we're going to talk about later to assist in these tangled titles. And we'll go over that as well. And then the final thing that I said that I wanted to do was make sure that the office was diverse and reflected how Philadelphia looks and how it is fairly. And I'm very happy to say, with the team that I have gathered together, we have accomplished just to get the ball rolling. We have accomplished much of everything that I had promised. And one of the first things I did was made sure that that I wanted to hire a solicitor. Particularly, I was looking for a Black female attorney that could come and assist me, because I am only administrator. I'm not an attorney, and Register of Wills, we do not give legal advice. But I wanted to make sure that I had gotten somebody that could fill in to assist me wherever we needed to be assisted legally. But this person had to have the same passion that I had for the city of Philadelphia and for communities in general. And I did that with the hiring of Sharon Wilson, attorney Sharon Wilson, who is going to join us tonight. And in addition to that, I retained attorney Terry Booker, and I wanted some initiatives. I needed some legal advice on some of the things that I was going to do as at the administrator over at the Registry of Wills. And I hired, for the first time ever in its history, I assembled and started an outreach program, because it's amazing that not only do most people in the Philadelphia don't know that the Registrar of Wills is an elected office, but they don't know what functions that we offer or what services we offer as it regards to your generational wealth, your family's estates, your family's assets, your family's wills, just everything. And Matt, and when you say clerk of Orphans Court, most people don't realize that I also am in charge of the issuance of marriage licenses and the retaining of marriage records. And another thing that I do, I'm a steward over the safekeeping and protection of archives that date back to the 1600s. So I wanted to start this seminar or webinar, and even though it's an hour, don't worry, we're going to come back because we partner with organizations like you. So don't worry if you don't get everything, and I know you have your pens and paper out, because we record this and we broadcast this like we have rebroadcast most of them, so you can visit all our social media sites. But having said all of that, I feel like the first thing that I need to do, besides introducing myself as your Registrar of Wills and Clerk of Orphans Court, is I wanted to help you understand the history of this office. History is very important, and history help you understand the why is why things, and why did this ever come into existence, and why is this office necessary, and why is this office important, whether you own an asset or have orphan children or whatever. And so this office goes back to the 1600s. This office is a state office. We have to follow the Constitution under the first judicial district of the state of Pennsylvania. Back when the Quakers first came here to America, way before the Revolutionary War in the 1600s, they came over from Britain and they divvied up land and property. And some of the William Penn and the like, Benjamin Franklin, William Till, Betsy Ross, and anybody that is in your family that had property here in Philadelphia, for that matter, wanted to make sure that legally they could pass down or transfer their generational wealth. That land that they own, those homes that they own on that land, they wanted to make sure that in an event that they died, which of course they was going to die, whether it was through natural causes or whether it was through war or some of the pandemics that we had in this country, they wanted to make sure that things that they own, they had ownership in, was able to pass down to generations, whether it be through their wives or children, because we all understand at one point most of the owners of land was white males, and so they came up with the Register of Wills, and this office has been in existence for that long. But here we are in 2020, and the average person don't even know what this office does, what it doesn't, what it entails, until death occurs in their family, and they're like, "Oh, wait a minute. Okay, somebody died. Okay, so this is my mom's house, and it's 5 of us. How do we go about divvying it up? Or this was my aunt's house, and she didn't have any kids. How do I be able to get legal ownership with this house?" And that's when you start asking questions to people that don't know as well as you. So you start asking the funeral director, and then you might call your auntie, or you might say your block captain, D. Dukes. Listen, my mom died and I want to sell the house. And you go and say, "Oh, no problem, it's a realtor. Hey, I want to sell this house. This is my mom's house." And the realtor looks on that title of that house and say, well, you have to probate, because that house, you can't sell it because it's not legally yours. And you're like, "Probate, huh? What? I just wanted to sell it and put it in my name. I just want to," and it doesn't work that way. And so I don't know what happened over the last 300 to 400 years, even in the last 40 years that my predecessor was in the office. But what I do know is we are losing a lot of land and property in the hundreds of millions of dollars. And it's only because of a technicality of not understanding the importance of making wills. So me, as a state agency that has to follow the first judicial district of Pennsylvania, our mission is to preside over the protection of your generational wealth. That's what I do. I make sure that residents of Philadelphia who own property, land, have minor children, have assets, have stocks, bonds, or whatever, once they die, if they have a will, in which we have to encourage people, and we're going to teach people about that importance. Sharon will go over that more as we talk about what's going on here in the city of Philadelphia, and the fact that without a will, you are literally giving permission to the state of Pennsylvania to decide where your assets go through what we call intestate. So whether you make a will or not, a will is already made up. And that will favors biology. And that will may not have anything to do with who you want to leave your home to, or whether or not you have 4 children, and when you die, the fighting that goes on simply because you didn't make a will because you was either superstitious or you was not financially literate. And so this webinar is just going to go over some basic things, but we are available to you all. And we are going to come back, and we're going to help you all just to understand just some of the things that you need to understand and be able to go and talk to your fellow community about, so we can sustain this tsunami that's going on called gentrification. So we want you to all to plan and think about what your life would be like for your loved ones who would, what would it look like without you there? What would it look like without Big Mama there, without Mama and that owns this property? What would it look like if they weren't there? Who relies on you? Who relies on you emotionally and financially? What things have you left undone? What bills have you left? What the second mortgages? If you have a mortgage, do they know your mortgage company is Chase Bank? Do you have you left documents to make somebody your executor or your estate so they can conduct your business? That executor has to pay your debt and disperse of your assets. Have you planned for that? Have you prepared? Do you have a list of your assets with the addresses and where they are? You know, you may have assets that you inherited from North Carolina. Who knows that? Is it in a list? Have you prepared your heirs to be able to conduct the business when you're not here? Do you have a list of people that you want those assets to go to? You have 4 children, you have 3 children, you have grandkids. Maybe you want to bypass one generation and leave it with your grandkid. Whatever it is, you have to, and you have the right to be able to make that decision simply by making a will. Make sure you have your important documents, your birth certificate, your social security cards, you know, your bills, because they have to pay the debt, the executor. And the executor could be part of an heir, but who do you trust? Which one of your children? Which one of your nieces? You know, or maybe even a lawyer that you trust. And if you do have a will and make a will, and we'll tell you about the types of will that you, the right type of will you have to have in the state of Pennsylvania that will cause the least problems, or make you come into our office and leave in 15 minutes, or make you come in, or have you come in our office and have to make an appointment and come back for a citation hearing so we can determine who would administrate that in your best interest. And I got to listen to all the fighting that goes on amongst your families. What you said, what Big Mama said, she said she was going to leave it to me. This one no good. All this stuff could be avoided if you simply wrote down and say, hey, this is how I want my estate. These are my final wishes. Because we're going to die. But the planning that you need to do, the planning. So that's why I decided to have these webinars. And I think that is appropriate that, don't y'all love it, D? Normally we would be running to a recreation center, or we would be running over to a police station, you know, and getting papers together. And then we can do it right now through the internet. And we can record this, and you can send this out to your members so they can understand exactly what's going on and how they can protect their generational wealth, because we are losing wealth by the hundreds of millions of dollars. So let's first talk about what a will is. And by the way, I want you all to understand what I'm telling you and what I'm talking about today is for the state of Pennsylvania, not for the state of Jersey, not for California where your sister lives, not for North Carolina where your auntie lives. This is all the state of Pennsylvania. So this is basic stuff, everybody should have a will, but how the laws work depend on what state you live in. So we're dealing with the first judicial district of the state of Pennsylvania. And so we knew, the men knew, hey, listen, we're going to come over to this new land, and we're going to divvy up this land, and we're going to make sure that, you know, I want my land over here by the river, you know, because, you know, this is where the docks is, and this is where everything is. And then we moved out and built row houses, and, you know, we all migrated, Black people migrated from down south so we can get that American dream and buy the row house and live, you know, happily ever after. But the thing that we aren't doing, D, is we are not planning our estates. We are not preparing our children.
Exactly.
We are not protecting our generational wealth. We are not protecting it, and it's costing us land. And at this point now, the way gentrification going, COVID, and just totally how business is being done now, you know, with the businesses closing down, the mass, you still have to pay mortgage, you still have to pay taxes. And all we're going to do at the Registry of Wills is to attempt to prepare you so you can pass your generation down to who you want to pass it down to, and not who the state of Pennsylvania biologically is going to pass your wealth down. So the first thing I just want you to know that a will is just a document you write during your lifetime that distributes your assets. So you can write a will now, and then you can 2 years later change it, because maybe one of the people that was in your will passed away. So you can remove them off the will. You know, your will is not effective till you die. And I've been getting so many phone calls saying, hey, I have my will, can I come register it? No, you're in the state of Pennsylvania, in my office here in Philadelphia, you do not register your will. We do not see your will until you die, and your executor or whoever you left your will in care of bring it. If you was in Maryland, you would register your will. In Pennsylvania, what you do with your will is you get your will made up, you put it up in a safe place. You leave it with your attorney and let somebody know, my attorney has my will and my last will and testament. When I die, go to Mr. Attorney, whoever, and get your will. Or you can have a safe box that you have that have all your important papers in. I recommend that you get one that's fire and waterproof, and you tell somebody where your will is, because you can have a will and it could be the most thorough will ever written, and you don't tell no one where your will is, and they can't find it, and you're dead. So we do not store wills at the Registry of Wills. So a valid will in Pennsylvania must be signed by the creator of the will or the testator of the will at the bottom. So you list your assets, you list who they want to, you sign it at the bottom. You don't put more assets under your signature, because that's not going to count. Everything above your signature. Best practice, hire an attorney or consult with all the attorneys that Mark is going to put in our chat box. We have a list of organizations that come out and do free will workshops, and they will do it. It's income-based. It's based on your age, seniors. They help seniors, Senior Law Project, Christian Legal Service, Community Legal Service, that can help you make a will until you can get to one of them or until you can afford it. And there's no way in the world you should say you can't afford a will. If you go to a lawyer and it's $300 to $400, $500, depending on the complexity of your estate, put a down payment on it and say, hey, listen, every month I'll send you $50 until we get to the last 50 so we can make a will. If we can save for the Bahamas and the red bottom shoes and for everything else, the least you could do is invest in protecting your generational wealth so your family won't have it hard. It won't be so hard on them. Because at this point now, if you look around, and I've always was very, I always admired Wynnefield. I really do. I drive by Wynnefield, and sometimes when I'm driving by with its Wynnefield Heights, I don't even believe I'm in Philadelphia.
Thank you so much.
And then as we get closer to Overbrook, I mean, it looks like everybody sweeps in front of their house. It just looks like your property value is going up. But another thing I noticed about Wynnefield too is years ago, I used to do interviews, field interviews for studies, like drug studies and the different studies. And I noticed that a lot of the houses had generations in it. In other words, Big Mama lived there, and her daughter and the granddaughter was living there too, but she was away at college. Mm-hmm. If you go to New York, I'm telling you, there's no such thing as, just you living in a house. It is, because of the expense, these are family dwellings. I noticed that when I did those studies because I had the data, and I was like, okay, so I'm doing a study for teens and, you know, the drug study. So I'm looking at the teenager, and Big Mama come to the house, but I got to get permission from the mother. And I was like, you know what? Wow, people actually do live together. So I did notice that about Wynnefield.
Yeah, we do. My
Another thing
grandmother
that I
lives there.
love to notice about Wynnefield is y'all are near city line. You are near all those parks, you know, and so, you know, think about it. If you all are, you know, learn how to cohabitate, uh, you know, as generational families, I want to make sure that you all understand that you need to have wills, because there's no such thing as heir property. Oh, when my grandmother dies, heir property automatically goes to me. And then when I die, it automatically goes to my daughter. That's not how it happens in the state of Pennsylvania. There's something that's called probate. There's something that's called estate tax. There's something that's called that you have to close out your affairs. And whether or not you probate or not, once you die and you own a property in the state of Pennsylvania still, there's still that fee is still ticking along with interest. And so a lot of people say, listen, I'm living here, I want to stay here. Big Mama died or my mom died, but listen, I want to keep the bills. You know, we had the budget and, you know, whatever you're saying. And you don't realize that even though you think that's your home and you have legal or biological rights to it according to the state of Pennsylvania, you still don't own the property. The property is owned by the person that's dead. And it could be your mother, your grandmother, or whoever, but you can't do legal things with it. So what kind of legal things can you do? You can't sell it. You can't pass it down. You can't take an equity loan out to fix that leaky roof. You can't, if you qualify for basic system repairs to help you fix that leaky roof, you can't qualify for that grant. Why? Because the house is not in your name. It is not legally yours. You can't get FEMA if it's a natural catastrophe. Just a couple weeks ago, we had a fierce storm. We've been having lots of them lately. Luckily, we're not down south where the roof blows off. And then the government comes in and assists us, because it's one thing to have insurance, by the way, that you can't get because the house is not legally yours. But if you have insurance, you pay for it, you make a claim. FEMA is government insurance. They bail us out. You can't get it because the house is not in your name. So when you make the will, you have to be at least 18 years old. And the best practice is to have two people witness and have it notarized. And you have to have it notarized. You don't have to have it notarized. It's not, you know, and you could just have it and sign it, and it could be legitimate. But it could be some complications when you come up and some of your family members contesting, like, that's not her signature. You know, she wasn't in her right mind. And then you have to come to me, and then I have to decide based on the evidence that you present, your family present, whether they're feuding or they're together. Still is another step that you have to take, where you can avoid that whole step if you make a will. And so my counsel here, Solicitor Sharon, is going to just give you a few tips about what probate is. It's all on our website. We're going to give you all that information. But some of the things, one of the things that I did leave out, that I never like to leave out, is the type of will. When you make a will, that you make sure that you seek counsel with a lawyer that practices wills and estates. You know, I know, you know, lawyers, that's a broad term, but some of them practice in entertainment law. Some of them practice in property rights or whatever. You want to make sure you search for that attorney that's what they do. That's their specialty. And so Sharon explained to them one of the things they get, so they don't have to, when they bring the will, they don't have to hunt down those two witnesses. We can avoid all of that.
Good evening,
Madam
everyone.
Register, before Sharon starts, since we were talking about wills, If it's all right, I have a quick question that's actually related to the will, or do you want to go ahead and start talking about probate, Ms. Wilson?
No, because probate is directly connected to the will, and we're
Okay,
going to take the questions later, so it won't throw off our
okay,
train of
no
thought.
problem.
You know,
Okay,
we'll have those questions, but probate and wills are one and the same.
okay.
All right, go ahead, Sharon.
Oh,
Not
sure.
one and the same, but
I was just saying
you
good
wanna
evening
weave
to
it.
everyone. And in terms of getting an attorney that actually practice in this area is very important. And just today, I was counseling an attorney who didn't really understand why they needed an additional document when they drafted a will, because they dabble. And you don't want an attorney that dabbles. You want an attorney that actually, you know, practices in this area and writes many, many wills. And so they'll be able to write yours, even if it's a little off, you know, the beaten track in terms of what you ordinarily see. Now, as the register mentioned, your will isn't effective until you die. But when you do die, then someone will take your will to City Hall and ask that it be validated, that City Hall at the Register of Wills office says this will is legal, and now we are going to actually carry out the wishes in the will. That process is called probate. So in that probate, what you can expect is, one, that you will have to pay a fee based upon the value of the assets in the estate, that you will have to present identification if you are the executor in the estate. That's the person who's going to carry out the wishes in the will. And that after that time, when that information is presented, that you will then get formal letters indicating that you are the executor. And then you can go about doing the business of settling that estate. Now, probate is fairly easy if you have a will, but if you don't have a will, then it can get to be a little bit more complicated, because now, in most cases, every family member who is in the same branch that you are, for example, if your mother were to pass, you and every one of your siblings has the same ability and right to administer that estate. So if you want to be the one that does it, you got to get your brothers and sisters to sign off, every one of them. And if you only have one, that may not be a bigger problem. But if you have four, it can be something of a headache, because until you get them to sign off, the estate cannot be opened. And if you can't agree, then that's when we'll have to go to a hearing that the register mentioned earlier. And then she'll have to decide, of y'all four arguing siblings, which one of them should be the administrator of the estate. So the thing I want you to leave today knowing is that when you go to open an estate, you will bring your will, your death certificate, and your identification. And if you have a will, the process can be fairly simple. Without a will, it can still be simple if you can get, you know, agreement among all of the various heirs. But if you can't, it could take a little bit more time. And the other thing is, if you don't have witnesses to that will, if it's not what the register mentioned as self-proving witnesses and notary, then you have to go locate the witnesses. And you also have to bring them down to probate, because they have to sign documentation in front of a probate officer. And in the middle of a pandemic, that's not always something that you want to do.
Or that witness may have died. So you got to find out, you know, if you get the type of will, you tell the self-proven will. So when you go to your attorneys, make sure it's a self-proven will. So those witnesses that sign that will in front of that attorney, when you come, or your executor come to bring the will in, they don't have to hunt those two witnesses down, because it's self-proven. So a lot of times attorneys, that's why it goes back to consulting an attorney that actually does that as a practice, because sometimes wills are simple and sometimes wills, there are complications with it. You may still be married to your ex, or one of your children may have died and they have children. So it's a lot of complications. So it's not a will, it's not really like this one, you know, type of will that you get. the will can be customized. It should be customized to your situation, and only you know it. And you are to decide, hey, this is how I want my estate handled. You are the person that we agree that I trust that will, minimize any complications that may come up. I made the decision. I'm dead now. It is what it is. As opposed to I'll let y'all take care of it. That is one of the worst things and one of the worst decisions that you can make. And quite frankly, in my opinion, is selfish. So you're putting your business in the hands of your children or whoever you want to leave your state to, in hopes that, look, I don't have to worry about it. They can deal with it. No, because every time I just had a case, it just was like crazy, this thick, and the sister was fighting the brother who died, who was the executive. So now his daughter is his executive, but it sometimes is very sad, because sometimes you may say, listen, all my kids, you all had houses or you had a chance. I want to leave this to my granddaughter. I'm proud of her. This will help her out, this skip a generation or whatever. And you don't leave the will, but they all know that you said that and you die without a will. And then the state of Pennsylvania goes by intestate by biology, and that means the next of kin is not the granddaughter. It's your kids, the ones that you said that you didn't want to leave it to. So do you believe, or can you trust, while you're 6 feet under or however cremated, that every single one of them are going to say, hey, we're going to sign over renunciations that we have no rights to this property because mama said that baby Jamila should have had it. Come on, that's not going to happen. And it's just called business. And it's the business that we have not been taking care of in Philly simply because we haven't been financially literate. And that is what my mission is, to make people like you, D. Dukes, you, Miss Susan Stark, meeting Ty Valentine, all the people who took the time out in the evening to not only get this information so they can protect their generational wealth, but what I hope is that you can give this information out to your relatives, to your block captains, to your siblings, each one teach one. So, they may not have the chance, or they may not be on the, digital divide. They may not be able to get to this webinar. We have physical leaflets that we can send to you. We have, we are all branches of social media that are helping people. And we are helping people because what we're finding, and we have found, and it's already, statistics on there, that when people do not leave wills, particularly in that one row house that many of us only own, it becomes a tangled title. And that tangled title was what I told you about. That tangled title is a person that may have ownership interest in a property, but his or her name is not on the deed. Someone's name is on the deed, but they're dead. There's some other cloud or problem with the title. You can't, even if, say for instance, you had a 30-year mortgage and 20 years you passed away, it was 10 years left on your mortgage. And your children wanted to say, hey, we want to keep this house. We want to make arrangements to continue paying the mortgage. You cannot do it legally because it's not in, you didn't leave the will. So it can name your executor. So your kids can come down to me and validate the will, and then they can get short certificates so they can go to the mortgage company and say, hey, my mother passed. I am the executive over the state. Here, I will start paying this mortgage so you can pay it off. Or if you own the home, you say, hey, I live in North Carolina. My brother lives in California. We're not coming back to Philly. You left a will. They probated. They put it up for sale. They split the assets after all the debt is paid. Or you don't leave a will. One lives in North Carolina. One lives in California. Who do you think are going to keep coming back and forth to make sure the lawn is mowed? Make sure nobody didn't break in it. Make sure people aren't swatting in it. Make sure people aren't stealing the house, because we get a lot of that. A will protects you, and even We have a partnership with the Record of Deeds, which most people think that when they come and probate, they think they get the deed changed. With us, no, you have to go to a totally different program in the Record of Deeds, and that's where you transfer the title. They have a program now that as you could, deed dukes, you can call them and you could register your property with them, so you will get an alert if something is going on. If the title is transferred, somebody will send you an email saying, hey, some things is going on with your estate. You could be living in North Carolina and say, no, I didn't, within 2 weeks as opposed to 4 years. So we got these tangled titles like to the tune of 14,000, and people are not able to salvage or save or preserve the house because they don't have no ownership in it. And when you don't normally have ownership in a house, you say, listen, I put my money out, but this is not my home. And my brother's living over there and he's not paying any taxes. He's not doing anything. And no, if you would leave a will, you could say, hey, listen, I want you to sell the house, buy your brother out or whatever. But our community needs to understand the importance of making that decision for our families, so the transfer of that generational wealth would be easier and don't end up leaving it to the point where the family is so frustrated they leave it and become vacant, which is not particularly in Wynnefield or Wynnefield Heights. But if you go around all over the city, South Philly, North Philly, West Philly, you see all those vacant properties and vacant lands that were abandoned. Somebody actually owned those homes. And so I had recognized that that was a problem, because people in the legal community who are assisting people and trying to get them to get out of these tangled titles so they can get the houses legally in their name, so they can conduct business, so they can have a place to live, because rent is super high. And now they're saying that, okay, we can help them, but your fees are too high over there, register. They can't afford the probate fees, $300 to $500 per estate. And so what I did is as an administrator, I came up with a program called Probate Deferment Initiative, which would defer the fees so you can get on to the next step of transferring the title, which is saving money for not only you and an estate, but it's saving time and money for the attorneys who are trying to assist you in your community to get out of these tangled titles. And we just started this program last year. We just kicked it off, and I'm very proud of that, because tangled titles cause people to abandon their houses. They leave them vacant because they can't apply for grants, loans, utility discounts, or real estate tax abatement. The tax abatement, you can't get that tax abatement because you don't own it. You can't enter in payment plans for taxes or water and sewage costs. You can't sell or transfer your title to your children. You can't get property insurance. And so the city of Philadelphia has a Tangled Title Fund, and it's a grant program eligible for low-income people or moderate-income people. And this program is, only funded to a certain amount of money. And they were saying that the fees was too excessive in our office. And so I simply deferred it. So it means like we're not going to come knocking on your door if you leaving it, you living in it, and going to pass it down a generational wealth. However, you decide to sell the house, by law, we have to collect the taxes or the fees. And another reason, another thing that we're finding, the reason why people don't know when somebody dies, they have to, finish it, finish up the person's business. They think they're going to avoid the inheritance taxes, which is really not high, because you're only taxed on how much the property was worth when the person died. And they will take payment arrangements as low as $25. And so Sharon is going to tell you all a little bit about inheritance taxes before we get to the questions, and why it's impossible to avoid them. And the fact that you would think that you can avoid those taxes could also cause you to eventually somewhere down the line to lose the house, because after 9 months, they start accruing interest. If you pay them within a certain time, you get a 3 to 5% discount. And so a lot of people think that, I'm not saying they're being slick or think, they just don't know. They just don't know how to conduct the business to be able to, close the deal and transfer that estate, or transfer the house into whoever name, so you can sell it, or you can just live in it and not lose your home and not be homeless or be renting forever. Rent is so high in Philadelphia. And we're talking about Wynnefield Heights. And I always tell people, like, you should be proud of wherever you live. I live in Southwest Philly. It's not Wynnefield, but it's still beautiful, because I make sure that as a block captain, I make sure that we keep it clean, and people are starting to do more things. I'm noticing, because they see that, hey, let me just keep on to hold on to my row house, because you're not going to be able to afford to buy one. And we're talking about Wynnefield. You're talking about those huge estates that you work hard to earn, or your grandmother or your mother or your father. Why should we be losing homes? So Sharon is going to talk to you about just some pointers on the inheritance tax, because not only do we validate wills, we are the collectors of the inheritance and estate taxes. Just say we probated estates. I assign executive privileges. I issue short certificates when that person dies. Once you probate it, we have to give you certificates so you can go to the agency that's holding the stocks and bonds and get it released to you. You can go to the bank if it's $10,000 or more, so it can be released to you. So you can go to the mortgage company with the short certificate, so they can talk to you about how you can finish paying this mortgage and conduct the business, so the house or the title could be transferred in your name. Sharon?
Yeah, sure, Madam Register. The inheritance tax is a tax that we pay based on how we receive the transfer. So if you receive the asset by virtue of death, then you have to pay inheritance tax on it. If you were living, you'd pay tax on it, because if you sold a home, you'd pay the real estate transfer tax. And if you gave away a certain amount of money, you might have to pay a gift tax. So they don't let you get away from paying tax on your transfer just because you die. So if you receive an asset, and usually real property like your home, if you receive an asset by virtue of death, you have to pay the inheritance tax. And the amount, the rate of the tax is dependent upon the relationship of the person that died to the person who's receiving the house. So if as a parent, I give the house to my child, that transfer is exempt from inheritance tax. If as a wife, if I give the house to my husband, that transfer is exempt from inheritance tax. However, other transfers, like to siblings, are not exempt. If I give it to my brother or my sister, that transfer is not exempt from inheritance tax. So the first thing that you want to do is to figure out what's the relationship between the parties, and then you want to figure out what's the value of the real estate on the date of death, because that's what you're responsible for. And I say that because some people don't get around to paying the inheritance tax too many years later, and they're concerned that they have to pay the tax based on the value of the house currently. But no, you pay the tax based on the value of the house of the person that died, even if they died 5 or 10 years ago. And the thing to remember about the inheritance tax, it's not that onerous a tax. It's not that large unless you let it accumulate for years, and the interest can accumulate. And the thing about it is that the state of Pennsylvania isn't always very aggressive about going after it initially. I always say likelihood is that nobody will come to your door and knock and say, hey, you got to pay your inheritance tax. They're not like the IRS. They're not on you. What they do is they lay in the cut and they wait. And while that tax accumulates and accumulates, then that's when maybe the department gets around to telling you, hey, you owe the inheritance tax, and this is the amount of interest that you owe because you waited all of that time. So the thing to do, don't wait. Don't wait. Have the inheritance tax calculated, you put it on a tax return, and then if you can't pay the amount of monies, because the one thing I do know about some of those big houses, some of them got a big value attached to them as well. So if you can't pay the money, then you can work out a payment plan. And that's what I would want to see you do. Because if you think just because I'm not paying it now, I'm, I don't have to worry about it. That's not true. It'll catch up with you. And also remember that most title insurance companies will require that the tax is paid before they sell. They don't want any liabilities. So you'll have difficulty selling the property if you don't pay the inheritance tax or don't have an arrangement for it. And don't let non-payment of inheritance tax stop you from taking advantage of all the benefits that you can get from putting the house in your name. Some of them we already talked about, some of the programs for repair and assistance, your tax rebate, your interest mortgage deduction. There's a whole bunch of them that you can't get if you don't put it in your name. So don't let inheritance tax be a bar to that, because you can conquer that. You have a big house, and I know that the house may be worth a lot of money, but if it's the house that your grandmother bought, that doesn't mean that you could afford now what she could have afforded 20 years ago. But you have to at least put the value on it, make an arrangement for it so you can live in it. So now you have a way to pay the inheritance tax. The register has provided a way for you to defer the probate. So now you have no excuse to let that house go anywhere but exactly where you want it to go.
And don't be scared. Don't be afraid. I hear, um, I know, and Mark can tell you this, Mark Arell, having working for one of our CDCs around here, when people are having hard times and their house is going up for foreclosure, and you're so depressed and nervous, you don't want to open the mail up. You just don't know. And it's all kinds of programs that are out there that can assist you if you jump on it early. So what I'm saying now is the education part of what I'm doing here at the Registry of Will is preventative measures. And a preventative measure is to make a will. Okay? However, because you didn't know, or your mother didn't know, your grandmother didn't know, now we're going to take it to measures that we can be proactive so you can save the house. It's no time to just walk away from homes in Philadelphia. And there are attorneys that can help you navigate it, help your brothers and sisters. Say, for instance, you say, well, my sister don't speak to me and my brother this and that. You can still come and request to say, hey, I've been living in this house. I've been paying all the bills. I have receipts. I would like to be the administrative over this estate so we can figure out how we could get this title in my name and make arrangements to pay my brothers off or sisters, or simply if they won't agree, that we'll sell the asset and then divvy the money up from there. But just to say, listen, I'm just going to sit in here and I'm going to walk away, or I let my brother live in there and I'm just going to leave that home. It is not the day and time to be losing homes in Philadelphia, PA. And as the Registrar of Wills, I believe it's my responsibility to help you all understand the importance of making wills so you can protect your estate. And in the event now that that didn't happen for your family, we're giving you ways to stay in your homes. And so you can make sure that, you can confer. Mark will put up the, we have a whole list of attorneys that give legal advice. And by the way, we are one of the only, if not the only office that remain is open in the city of Philadelphia, because we are essential. So we are open by appointment. You can contact us, roll online at phila.gov, ask us any question as it regards to probate estates, short certificates, marriage licenses, marriage records. And we have remained open during the pandemic. And we felt that we needed to help you all just in case with people dying in COVID, this is just not the time not to be wanting to talk about wills and estates. You know, your grandmother don't want to talk about it to you. Play this tape back, or go on my website and play the tape and say, hey, listen to this, and just make them listen to it. You know, because no, you know, of course, many people don't know want to die because you don't know, there's uncertainty about it. But simply, this is not the time to be losing wealth. Let this
Register, there is one thing I want to point out. The transfer from parent to child is exempt during the lifetime, but not during at death. That's where the planning comes in. So if you, for example, a parent were thinking about transferring a house to their kid, and I get this question, how should we transfer? When should we transfer? If a parent is transferring it to a child during lifetime, may actually be better because you don't have to pay the real estate transfer tax. But if the house gets transferred during death, then there will be a smaller tax to pay, a smaller inheritance tax to pay.
And of course, Dee, you can email me any question, anytime, and we will make sure that we would send it back to you, and we will assist all the residents of Wynnefield and all the members of your association.
Thank you so much.
You're welcome.
This is some of the more common ones that I receive, and those are the ones that we're going to answer, and we're just going to run through them pretty quickly today. Usually I do get questions about when there's more than one person's name on the deed. So if, for example, there was an administration, no will was left, and all of the siblings, all of the brothers and sisters end up being owners of the house. Well, who's responsible to pay? Especially if one person lives in the house. As far as the law is concerned, you are all equally responsible for the expenses of the house. Now, there may be some offsets for what one does if they live in the house, or you know, or maybe somebody calculates additional rent on the one that lives there. But as far as the law is concerned, you are all equally responsible to pay the expenses. You should all equally share on any rent that's generated by the property as well. We talked about inheritance tax. Oh, sometimes people also talk to me about the best way to transfer a deed. We talked a little bit about that just now. You really have to look to see what the goal is, because sometimes the real estate tax is the biggest thing that you're trying to avoid. And other times the inheritance tax might be the biggest thing that you're trying to avoid. It also depends on the age of the people that you're thinking about transferring it to. So there is no one best way to do it. If you're talking to an attorney, let them know what your goal is. My goal is to give it to my grandchild who's currently a minor, or my goal is to make sure that my son takes it, but his wife does not, which I get that a lot, by the way. Or my goal is to make sure that the house goes to some family member. So you tell the attorney what your ultimate goal is, and then they'll be able to tell you which way is best. Is a straight transfer best? Is during lifetime best? Is a trust best? Which of those options will fit you? The other question I get a lot of, people want to know about Medicaid. And they say, okay, they know that there's a provision and that Medicaid that they believe comes after your house. What really happens is, as you know, you get Medicare usually based on your age. So that once you get to a certain age, you're eligible to receive Medicare. Now, Medicaid is additional assistance that you receive in the event that you can't pay for nursing home care or other medical expenses. So what Medicaid says is, if you have a real property, if you have a piece of property, and you had it within the last 5 years, we're going to add it back in. Even if you transferred it away, we're going to add it back into what we consider your assets when we're trying to determine if you are eligible for Medicaid. So people often want to transfer that property out of their name so that Medicaid can't use it, you know, to figure out the eligibility. And then what will happen if you fit within the 5-year transfer period, they will generate what they call an estate recovery bill, a bill of every medical expense that they paid for you. And I have gotten them, and they look like encyclopedias. And then they will add that up, and they will make that a lien against your property. So that's why, again, it's important about timing. Is now the time to transfer it out of my name? Am I feeling ill? Do I think I'm going to be in good health? Am I going to make it past the 5-year, period? So these are all things that we have to try to contemplate. And it's somewhat of a guessing game, but you have to figure out what's most important to you, and we make the best guess. And the last thing I wanted to address is the question that about penalties regarding inheritance tax. The penalties used to be assessed if there was no return filed. Depending on the year of death, they stopped doing the penalties and they only do interest now going forward. I think they stopped, I want to say in 85, but don't quote me on that year. You have to look. So that's what you asked me about penalties. There's interest, but not penalty. And the last thing I want to say about probate, one of the things I will tell you, especially now, especially during a pandemic, probate takes longer than you think. We had several situations where people have entered into agreement of sales, they're selling their house and then they go to probate. No, go to probate first and then sell your house. It takes longer than you think. There's always some little thing that needs to be attended to, especially if there's not a will. Then you're running around trying to find people, affidavits, all of those things. Just remember, it takes longer than you think. And that's why you're going to try to avoid it by drafting a will. But if you can't, then you just have to plan accordingly. Okay, that's what's my run through.
Did we touch on the question that you wanted to ask?
Yes, you did. Yep, you did.
Yep. I always say at the end, wait, because we all have those same questions. As an association, a residents association, I really commend you because we a lot of this is volunteer.
Yeah.
I know how it is. As a block captain, we're volunteering, but it is so important. At this point in Philadelphia, I don't know if anybody has visited New York. My daughter lives there, and it is like you can't afford it. I mean, it has to be families living in there, and at the rate. It is an extreme seller's market. Like if you put your house up for sale, it'll be going in a week now. Everybody is coming here. This is the hottest thing. We got the best music. Despite the pandemic, everybody's trying to come to Philly because it's still affordable. And Wynnefield, your area is it has been sustainable. You have elected officials in that area that are attentive to people like us as block captains, and that's good. You're fighting for the resources, the roads and stuff. And all I'm saying is be a friend to the Register of Wills because we are your friend. We are customer friendly. I demand that. We all trained professionals and we are willing to go above and beyond. So anything you need, any tools, any leaflets. I see Mark, keep in touch with Mark. Mark has been a community activist through and through. He's been involved in CDCs. We're there on the CDC associations, and the residents associations are so very important. So look for some grants. Right now with the pandemic, they need you because people are losing their jobs, or then they may be losing their houses. And although we have nothing to do with the sheriff, but I am a friend of the sheriff, and we are going to partner with some things so we can help. If it gets down to that, but we don't want you to get to the sheriff's. You don't have to get to the sheriff's if you own. And just like Attorney Wilson said, Attorney Wilson was saying that the inheritance, which is where we send $80 to $100 million per year to the state and inheritance taxes. We are a first-class city out of the 67 counties. Philadelphia is not, the poorest city. No, it's not. This is very rich. We live on rich land, and we want each one teach one. We want to help you. We will train you. We will train your residents. We will come back when COVID's over. We'll come visit. And we are access. Mark sends you, email us. We have like a 24 to 48-hour turnover. We respond to emails. We refer. We have partnerships with the Bar Association. We have partnerships with Community Legal Services. They are doing things online now as well. So just don't wait. Don't be a stranger. Thank you all.
Madam Register, I see a question that I'm not sure whether or not Attorney Wilson or Attorney Booker covered it. So I'm just going to say the question out, and whoever can answer. And then I'm just going to allow about 3 minutes for anyone who feels as though their question did not get answered. We have a few minutes that we can answer those questions. So there's a question that was asked earlier. I own my home and would like to add my son to the deed. He's 22, about to graduate from college this year. Should I have both a will and add him to the deed?
I'm so glad we asked that question. I did see that question, and it was my intention to answer it.
No problem.
So the answer is the one that he's gonna hate, Mr. Harris. It depends. Your son, what kind of young man have you raised? Does he take care of his credit very well? And yes, you should have him have the house in the will, even if you transfer the deed, just in the event that there's some issue with the deed. And also, is he ready for home ownership now, or is he ready for home ownership later? So do you transfer it to him outright, or do you put it in a trust? So those are some of the things that I would say you need to think about first before you go forward. Because when you add somebody's name to the deed, you are adding their credit to that deed as well. So when you go to sell a deed, they're going to pull up that young man's credit and see, what judgments he may have against him, what late payments he has against them. And those are things that title insurance companies may ask you to resolve before you can sell. So you need to be honest with yourself about, about the young person or however the age is before you add them onto your deed. You want to make sure you're not adding a liability on and making the problem bigger, but making it better. Now, if you intend to give him the house anyway and not sell it, then maybe it's not an issue, right? Because then he'll have to deal with his credit at the appropriate time. So again, it depends. He's a beautiful young man, right? He's very responsible. Good. But that's what you need to know. And if that's the case, then maybe adding it on via deed won't be a bad idea for you.
Thank you so much. I'm a proud mom, so I'm very, very proud of my son. He's graduating from Temple for journalism, so he'll be able to afford.
Just remember this: sons do things like they get attached to women who may not necessarily the same way that they are.
Right.
I hate to be the carrier of that bad news, but I got to tell you what I know.
Yep, I understand. I hear you.
Okay.
Thank you so much.
Thank you so much for that question. I have a quick question and follow up to that. So a friend of mine just recently, dad passed away, found out that mom had already passed away years ago, found out that they had all this property. Dad didn't really tell anybody that mom had all this property. So he wound up, oh my goodness, with all this property, but also with all the responsibility to the property. So should a parent, really similar to what was asked, should a parent, for inheritance tax purposes, add the son or daughter onto the property for inheritance tax purposes, if all those other things are great?
Remember, this is going to be my last question because I know that the register has another place to go.
Okay.
But what I'll say is, adding somebody onto a deed does not defeat inheritance tax, because if you're giving the person the property at my death, like I'm putting you on the deed, and when I die, you'll get 100% of the property. You're still getting some of that property by virtue of death. And if you're getting it by virtue of death, then you're going to pay inheritance tax, or at least it'll be owing. See, when you get two people's name on the deed, the assumption is that they own it 50-50 if you don't say how much. And then when one dies and the remainder owns it 100%, they just receive 50% of something. So then you can't defeat inheritance tax by that. That's what I'm trying to let you know.
Thank you so much, Madam Register, Attorney Booker, Attorney Wilson, Mark Harold, to everyone that played a part in being invited, but accepting that invitation to be a part of this so very important meeting tonight. I say thank you, thank you, thank you. The hospitality from you all is just, I love it. I'm so indebted and I'm so humbled. Thank you for being a part of this. We are definitely going to reach out. We're going to have follow-up meetings. I can't wait until the pandemic is over and we can meet in person.
Yeah.
But again, this information was so valuable to our community and to our city, and I will be certain to share it with all of our community, and with whoever reaches out to me, I'll be sure to share it. But thank you, thank you, thank you to everyone that attended. If you have any questions for me, I did put my email in the chat.
Good.
If you'd like to have a copy of the recording, that's also upon request. Email me at wraddukes@gmail.com. Madam Register, thank you. Thank you so much. I really appreciate you. From block captain to block captain, you are awesome. You rock. Appreciate y'all. So we are done. We are done. Thank you again. I'm going to conclude. Everyone have a happy new year. Prosperous, be blessed, and be safe.
Thank you again, Dean. My contact
Don't forget,
information.
any other questions you have, send them over to Mark. We'll answer them for you, okay?
Certainly
We'll make
will.
sure we answer
My
every
contact
last one of
information
your
is in the
questions.
chat as well.
Thank you,
so
Mark.
much. All right. Good night,
Good night,
everyone.
everyone.
Thank you
Happy
so
New Year
much.
to you.
Bye-bye.
Bye-bye.